Okay, we'll now hear the arguments in the marriage of Gust. And Ms. Brotherson, you may proceed.
Thank you, Your Honor. May it please the Court, Counsel. My name is Kodi Brotherson, and I represent Stephen Gust on his application for further review before this Court. From our perspective, this case presents a very simple question. How should the sacrifice be shared? After a 25-year marriage where both parties are capable of working full-time, should the burden fall to one spouse to support the other spouse after the dissolution of the parties' marriage? It also presents a related question. What do you do when there's simply not enough money to go around? When one of the parties does not have a six-figure income and they're not dividing a six-figure or larger estate, how do you balance the equities? As this Court is aware, the divorce changes the plans that a family might have had for their future and their support. They're no longer pooling potentially two incomes into one household, but rather supporting two households. And the goal has to be to ensure that both parties, not just one party, get to enjoy the standard of living that the parties enjoyed during the marriage to the extent possible. But when there's not enough money to go around, then both parties have to sacrifice and cut back and whittle down their expenses so that they both can survive equally. There are two issues before this Court. One, it was lifetime alimony appropriate under the facts of this case? And two, was the amount of alimony awarded to Ms. Gust excessive? The District Court repeatedly found that Ms. Gust was underemployed. She had no health issues that prevented her from obtaining full-time employment, but rather wanted to continue the two part-time jobs she had because she enjoyed them. Mr. Gust, on the other hand, worked full-time, and for a period of time during the marriage actually worked two full-time jobs. Because of his type 1 diabetes, this was causing problems with his health. He was an insulin dependent and wore an insulin pump. He'd had multiple surgeries on his eyes because of his diabetes, and he testified without contention that his diabetes was affected if he was extremely stressed or if he worked more than full-time hours. And Ms. Gust conceded that his alimony obligation should be calculated on one full-time income and not two. It's obvious that the parties in this case lived beyond their means. They had substantial credit card debt that my client was ordered to pay under the terms of the decree, whereas Ms. Gust leaves this marriage debt-free. Should lifetime alimony be the exception or the rule? It is our position that it should be the exception, reserved for cases where there is truly a need, where due to health issues, whether they be physical or mental, extreme age, or lack of skills, that there really is no likelihood that a party can work full-time and in any way be self-supporting. The unchallenged evidence in this case is that Ms. Gust could find a job paying her $30,000 a year. Now, I think you have to follow the district court if there's support in the record. The only evidence in the record is Ms. Steck's report that she could make 30. There's no rationale for.
So that's just an expert testimony. I mean, if you have a rental case and one expert says the fair rental value is $10,000, the court might say, well, it's not really $10,000 because surely, although you had a qualified expert testify as to the 30. It wasn't well within the district court's discretion to do some fact-finding and say, well, I really don't think that's realistic.
I think that's certainly part of the district court's job, and I think what the district court did is said she makes 15, we say she can make 30, what's in the middle, and sort of divided it that way and said that that was within the range. But I think she testified she could find a full-time job. She testified she'd only applied for one job during the time that the divorce was pending and couldn't remember how that what that job would pay. She testified she should find a full-time job. She testified that she hadn't applied for any of the jobs that Ms. Feck identified in her expert report, but that she would be qualified and have the skills to perform many of those jobs. But even assuming she can only make $22,500, the issue in this case is she working up to her full potential, and at what point does supporting her take away from supporting our client? And essentially this court has, or not this court, the lower courts have said that $2,000 for life, meaning until my client dies or she dies or she remarries, that he has to continue working at least full-time, if not at his current job, at some job that would pay $50,000, $60,000 a year, so they could sort of each get $24,000 from the job, to support her when she's not obligated really to try to do anything to do that. She's also 6 years younger, and she has better health than my client. And I think what the district court and the Court of Appeals did is focused on her, lack of work recently in a full-time capacity, and didn't say there's a point in time where she should be able to work full-time, and she can come back to the court and say, if she needs more, if she can't find a job, she can seek to have it modified. But instead we put the burden on my client to say at some point, I want to retire, but I can't. And I can't retire because I have this large alimony obligation I have to pay. And as this court is aware, the rule is voluntary reductions in employment are not a substantial change in circumstance.
Counsel, you've sort of hit on, I think, an important question, which is sort of the allocation. Where's the allocation of the burden when is it going to be on your client to come in at the time he retires and say, now there's a substantial change of circumstances, or are we going to not have this a lifetime alimony only to retirement and try to force her to come in and say, now the circumstances require that I have more alimony. So I guess this is all about the allocation of that modification burden, I think, and why is it more fair to put it on her than on your client?
Well, I think the court has historically put it on her, that we've historically said this alimony is for a term of years unless there are extraordinary circumstances that require a lifetime award. And if there are extraordinary circumstances, as in Marshall, as in Wessels, as in the recent Sisson decision, then we will give lifetime alimony. But otherwise, it's for a term of years, and it's up to the recipient to show to the court why they meet the extraordinary requirements of a lifetime alimony award. As I said, if my client is the one coming in and saying, I'm 70 years old, I'm 67 years old, and I want to retire, and this is what I'm going to have for retirement, my retirement account that you gave me as part of the divorce settlement, my Social Security benefits, whatever they may be, and that's it, then somehow he's got to overcome the voluntary reduction in employment unless his health has failed so bad or something like that. But he can't really ever retire because the burden on him is much different than it is on her.
Isn't there also a problem that he'll quit? He quits his job and then it turns around and finds out he can't get a modification and has to go back to work, which may not be that easy to do.
I think that's true. I mean, if he is 67 years old or 66 years old and quits his job and says, well, I'm going to retire now and I'm going to seek a modification, and if it's denied, then you're looking at a 66-year-old person trying to find a job that pays $90,000 a year so that they can continue to pay the support.
Let me ask you a question. When I was on the Court of Appeals, there was a case that I saw cited sometimes, In Re Marriage of Stark, that more or less said that when the alimony shouldn't create a situation where the recipient of the alimony is getting a higher standard of living than the payer of alimony. Are you familiar with that case?
I'm vaguely familiar with the case, but I'm familiar with the concept, and I think that's one of the issues we have.
And that's my question. Have we ever said anything about that concept in our case law?
Not to my knowledge has the Supreme Court addressed it. I think it's been repeatedly addressed by the Court of Appeals, but I'm not aware of any Supreme Court that addresses it. And I think that's one of the things that we're seeking here. If you look at the Exhibit 11A and B that are in the appendix, the financial expert in this case did calculations that showed if she worked at the same income that she was working at, and if she worked at a job paying $30,000 a year, what would the after-tax consequences be in the cash flow? And if you look at those, now the experts' range only went from, I believe, $500 to $1,500, so the $2,000 award would be above what the expert calculated. But if you look at those numbers, when she's continuing to work this job, her income is within a couple $1,000s after taxes of my client's income. And if you have her making at least $30,000, she's actually, after taxes, making more than my client. And I think if you also look at his expenses, he was ordered to pay all of the party's debt, which includes $60,000 of credit card debt, which to pay off in, he calculated 3 years, I believe has $30,000 of interest. So if you look at those factors in on his monthly expenses, which weren't challenged by Ms. Gust, he simply doesn't have the cash flow each month to pay the alimony award. Under trying to just make the minimum payments, he's $800 short a month after he pays alimony, and if he tries to pay it off faster, I believe he's $500 short with the alimony award. And so his standard of living simply isn't preserved by the amount of the alimony award, and certainly is not preserved if there's any hope that he would eventually retire.
I just have more of a practical question. You would agree that this woman is entitled to some alimony, is that correct?
That is correct. We've always said some alimony for some amount of time.
And so when we look at the general concepts of alimony, you've got traditional alimony, which is what we have here. We have rehabilitative alimony, and then we have reimbursement alimony. The only one that really fits into that triangle of type of alimony is the first one, which is the traditional alimony. So why doesn't that answer the question, really, that neither of these other ones really are supported by the evidence of this case?
I do not think that this was a reimbursement or a rehabilitative alimony case, but the traditional alimony case law has said repeatedly that you can award it indefinitely or for a term of years. And it's our position that those indefinite types of awards should be the exception, should be reserved for the cases like the Sisson case where the woman has terminal cancer and doesn't know how long she has, or the Marshalls and the Wessels type cases where they find out while the alimony is being paid that, again, they have some sort of illness that's not going to allow them to get up to the standard of living that was hoped for. There was also a recent case in the Court of Appeals where the woman had such severe mental health issues that there was no reasonable hope that she was going to do anything other than to be able to work minimally part-time. And I think those are the cases where you have the indefinite award. And in the other cases, to provide the incentive to the recipient to work up to her earning capacity, I think you have to give it for some sort of term of years, and there has to be sort of an equity to both parties.
Well, isn't that uniquely the purpose of a modification action, so that in a number of those cases are not actually underlying or the dissolutions actions themselves, they're modification actions, and that's, to me, uniquely the purpose of any type of modification action. So if, in fact, he makes the election to retire at 65, 66, 67, I do understand you run into the possibility of saying it's a voluntary reduction, but it's likewise not out of the realm of possibility that somebody's going to retire at 66 or 67, which would be a change in circumstances.
Well, would it be a change in circumstance if, you just said the likelihood is somebody's going to be retiring, and so is that not something that should be in the contemplation of the district court, that there will be a point in time where the parties are going to retire? And I think if you look at the modification cases that talk about changing from a term of years to lifetime alimony, the language that they use is that it is an extraordinary change in circumstance. It's not substantial, it's something more. That the change from a term of years to lifetime requires more than just a substantial change. And I think that's what we're saying, is if she comes in and says, I need this, something has happened, the burden on her is extraordinary to prove for longer than a term of years, whereas on my client, it's a substantial.
That just seems to me kind of backwards. That's the opposite situation, where we've gone from a term of years to a lifetime type of award. This time, you're asking to go from a lifetime and then anticipating or trying to predict what's going to happen 6 or 8, 9 years ago or whenever he decides to retire, and and saying then that, well, we ought to limit her to that at this point, and that just seems like we're looking into a crystal ball and trying to decide that. That can be decided at some point in the future as circumstances change.
Well, I don't mean to be flip, but that is what the district court largely does in these types of alimony cases, is they have to predict the reasonable changes that the parties are going to incur. And I think retirement at an age somewhere between 67 and 70 or 66 and 70 is a reasonable, foreseeable change in circumstance that should be anticipated by the court, that both of these parties at some point are going to want to retire.
Is there anything in the record about expected retirement other than, ordinarily? I mean, we know when Social Security kicks in, and you use 67 to 70, and I understand that. But is there anything particular in the record about the retirement of either of these parties?
There isn't, Your Honor. There was no testimony about the specific retirement plans of either party. I see that my time is up, counsel. Thank you. Or I'm sorry.
Thank you, Ms. Brotherson. Mr. Oliver.
Good morning, Your Honors. May it please the court, counsel. Very briefly, and as this court is aware, in a dissolution matter, we value assets as of the date of trial. What the appellant argues in this case is that not only should we value assets as of the date of trial, but that we should speculate or look into the future as to the value of assets, whether that's 5, 10, or 15 years down the road, to determine what an appropriate spousal support award would be. And that's simply not a reasonable thing to do. As the court's aware, there are many factors that go into the valuation of assets. In this case in particular, the financial assets had been depressed as a result of the economic downturn from 2008. They had recovered, and we don't even know what they are as of today's date.
Well, counsel, I get your point, but isn't it true that when the court is assessing spousal support, there's some amount of forward look? In other words, take for example the question of the extent to which the support receiving party might reasonably be expected to support herself or himself. I mean, that's sort of a forward-looking thing. It's not just, we don't just make that spousal support determination entirely on the circumstances prevailing at the time of trial, right?
Correct, Judge.
So then the question becomes, to what extent do we look forward? And do we look forward 8 years to Mr. Gust's 65th birthday, or more to his 70th birthday in anticipating what the circumstances are going to be in the future?
I don't know that we do. That's the perfect point of why there is a modification. Mr. Gust has that ability to come forward at that point in time and say, you know what, I'm pulling the plug next year. I'm done. My income will be this. It'll be fixed. I'll have this as an amount of money in my retirements. I'll have this as Social Security that'll pay me a monthly stipend.
He can take that, but do we require him to take that risk, as Justice Mansfield pointed out? What if he quits his job and then asks for a modification and doesn't get it because the court, for whatever reason, concludes that's not a substantial change? It was an election on his part that he shouldn't have made.
Well, if that situation was upheld, wouldn't that have been appropriate then from the appellate court standpoint? If he quit his job, support was ordered, it was continued at the same level, and now he claims he's at a financial disadvantage.
Let me put it this way. I mean, to follow up on Justice Hex is saying, we can kind of have a little mutual admiration here. Shouldn't the district court just make its best estimate of the future based on the circumstances? And isn't it a fact that most people generally retire? They don't work until their full life expectancy, till they're 80, 85, whatever, somebody of Mr. Gust's age. So shouldn't the district court take that into account when it's figuring that how long the alimony should run? Instead of requiring a party to come in and spend more money on lawyers and get a modification and the time and expense that's involved with that.
Yes, Judge. I think the court did do that in this case. Judge Hansen clearly pointed out that he considered the factors of 598.21a in determining that this was an appropriate type of support, that an indefinite term, as allowed per that statute, was appropriate based on the factors of this marriage. The fact that she had worked minimally during the course of the marriage, the fact that he had worked and earned a great deal of money and had all that experience, those are the bargain for positions of these parties in the marriage. So, I mean, should the court do that? Yes. Did Judge Hansen do that in this case? Certainly he did. The question, I guess the real question being raised by the appellant at this point is, he complains of the amount and the duration. Their argument really is, we want it to be, if I understand the argument correctly, that there should only be certain limited exceptions to a term of spousal support, those exceptions being some sort of physical disability. That's not what the statute requires. That's not what any of the case law requires.
About the Court of Appeals on the lifetime alimony issue, it said, at this point, we are not convinced Stephen will be unable to pay the alimony ordered beyond his retirement. The decree awarded him $167,000 in assets, including $135,000 in retirement accounts. Would you agree that that's a gross figure? That kind of disregards the $80,000 in debt he also has to pay off, right?
Well, yes, I would agree with that, and I would also enhance that statement, though. Of the $80,000 in debt, $20,000 of that was proposed interest payments. That wasn't actual interest. That was proposed interest. And the Court of Appeals also mentioned on, I believe, page 8 of the ruling that there was some concern that Stephen had begun to engage, once again, in the lead abatement business, which he had decided he was not going to engage in anymore at the time of trial, and mentioned that, and I think there was evidence in the record and in the appendix, that he had written the check from Sound Real Estate to establish his girlfriend and best friend's new business doing lead abatement, exactly the same thing that he had just sworn off that he was never doing again. In addition to that, Judge, I mean, if we're to look at those figures, Mr. Gust also took approximately $62,000 in cash out of the Sound Real Estate business during the pendency of the divorce. Stated testimony was, I'm going to pay off the debts. I have to pay off my debts. At the time of trial, the $61,000 credit card balance was still $60,000. He had not used those funds to pay down the debt. He had used those funds for, as he stated in his testimony, items such as vacations and meals, dates. The concept of we've got to look down the road and determine that it has to be a fixed period of time and we can determine what the factors are down the road, whether it's 10 years or 5 years, it just doesn't wash. And the reason is we don't know what happens in that period of time. We can speculate. Economists can come up with models that tell us we think this is going to happen. But the reality is we just don't know. We don't know if Mr. Gust is going to win the lottery. We don't know if Mr. Gust is going to inherit a vast sum of money that will render this entire argument moot at the time of his retirement. If he's sitting on several $1 million in retirement, is he coming to court saying, I can't afford this? It's doubtful.
Was there evidence as to the expected retirement funds available to these parties when they reach their expected retirement ages or normal retirement age?
I don't believe no. I would say the argument or the statement is no. There was a valuation of the assets as of the date of trial. What those assets would be valued at as of an expected date of retirement of one or either party was not part of the trial record.
Well, but, you know, the Court of Appeals indicated that the assets awarded to him included $135,000 in his retirement accounts. I mean, that gives me an indication of what he has separate and distinct from Social Security. But what about her? What's...
I think it was Exhibit A in the appendix that showed, I think she had about $48,000 or $56,000. I'm not exact on the figure, but she had some limited, and in fact one of those accounts was a Keogh account transferred from Stephen to Linda. So although she, and as the Court is aware, Judge Hansen virtually divided the assets and debts down the middle. Granted, Stephen took more of the debt, but he also took a vast majority of the assets in the case.
Yeah, but the assets he took were mainly in his retirement account, so he has this quandary. Do I cash out my retirement account to get equal? Because there's taxes on it, there's been tax paid on it. Or do I work my life and pay my debt down to save my retirement account? And that leaves him no money for anything else, if you look at the financial situation.
Well, again, back to the numbers of $2,012 versus $2,022. I guess that really becomes the question. What is that account worth in 2018?
But if you use the offset method, the offset method says that $2,012 and what it's worth later is going to have the same borrowing power. Because you could say what it's worth in the future, but what does it buy in the future? You have that other part of the equation. And most economists will use the offset method and say today's dollars are worth later dollars because the buying power goes down.
I would agree with the court, and that creates the absolute problem as to how we can value a retirement value as of the date of trial. We just can't do it.
Well, we don't know for sure, and I think you make a valid point that there's all kinds of contingencies that could happen. But what's the likelihood of expecting someone to work until, let's just say, age 80 to finance a substantial alimony award? I mean, one could argue that maybe he'll have the assets. I mean, and maybe that's right. But shouldn't the court make its best judgment as kind of the point from which the parties work for modification? I mean, if there's some dramatic event, of course, no matter what happens here, there's a possibility of modification. But instead of having the lifelong alimony, wouldn't it have been better to select a reasonable point of retirement, adjust the alimony accordingly, and have that as a starting point from which a modification would be determined?
It's certainly within the realm of what the court could do, sure. Is it an idea that would violate fairness in this case? No, I don't think so. However, based on what the arguments were and the facts presented at trial, the trial court, in its discretion, adequately determined under the factors of 598.21a that this was appropriate at this point in time. Again, should Mr. Gust's financial position change, or he anticipates it's going to change, I'm sure he will show up at the trial level, once again, if not the appellate level, to argue that he's not capable of making the payments that he claims he is.
I have a question here.
Yes, sir.
I think Justice Heck probably hit the nail on the head, at least for me. It is really an allocation of the burden of this future potential modification here. Give me your best argument as to why that burden ought to be on Mr. Gust in this case rather than on your client.
Well, I think first off, the concept of spousal support is for the purpose of trying to bring the party who is at a disadvantage to a whole. It's not Mr. Gust has to give this money away because he's got too much of it. It is Ms. Gust, Linda, is the party that really needs this for her support. If her expected income levels don't come up, what's she left with? Is she living on the $2,000 a month alone? Again, we're dealing with an older, as is the problem in this type of case. She, at today's date, is 55, was 52, or within days of being 52 at the trial. If she's not employable, let's just be frank about it. She's too old. A company can hire somebody much younger for less than they would expect to pay her, with less insurance costs, etc. Why wouldn't a company do that? Is she employable to the level that is being argued? Is she even employable to the level that the trial court felt? She is the party that's getting the Band-Aid. She's not the party that holds all the cards. I think that's the burden question. Mr. Gust is the whole party. He is the one that walks away with, albeit a fair amount of debt, he walks away with the earning capacity of $92,000 a year and a majority of the assets. He is the party that is capable of bringing this matter back to the court and saying, I can't do it anymore. I think that would be the best.
Counsel, am I right in understanding that Linda's current, her expenses are taken care of through her income of $15,000 a year plus the alimony? Is that all she receives?
At this point, well, at least as of the time of trial. What it is currently, I don't know. That's not part of our record.
Okay, but like you said, we focus in. And so the court has forecasted out that she'll need lifetime alimony. But was there any effort to try to determine how this $15,000 income that she earns will be dealt with at the time she's retired? Was there any effort in determining what her expected retirement funds will be plus her Social Security benefits?
There was not in this trial. Neither party dealt with that. In fact,
how can a court impose lifetime alimony when we don't know how much? There's no clue on what she might need when she retires. So if she's at $15,000 a year in income, that's something over $1,100 a month gross that she gets. And so she retires and she'll get Social Security and her retirement benefits. If that exceeds $1,100 a month, isn't she going to be doing better in retirement than she's doing now?
well, if we're to compare both sides to the same standard, we'd need to know Stephen's retirement benefits, his Social Security, whether or not there's inheritance, whether or not there's other income from other businesses.
But if the court doesn't know these things, should it even be determining this issue?
Well, I think the court's bound to determine that issue. Again, under 598.21a, the standards is set forth as to what the court should consider. It's equity. Do they get it right all the time? No, not necessarily. Is there a better way to do it? I don't think so, Your Honor. I think the problem is we cannot, once again, look into the future. There's no crystal ball for us to do that and say this is exactly where they're going to be. The mechanism or the safety catch here is.
But is the court looking into the future not knowing anything about what is going to be there?
Well, they have to.
Without even trying to find out how much Social Security benefits will be available and what her expected. I mean, she works for the school system. I think someone would be able to tell her pretty clearly what she'll be getting when in retirement benefits at age 65, 67, whatever it might be.
Well, I can answer that with the understanding that the financial statements indicated that she was working 2 part-time jobs, which equaled a full-time job. She was working 40 hours a week, but it was in 2 positions. As a result of being part-time, she wasn't being paid benefits. So there wasn't a benefit calculation to analyze in this case because she wasn't entitled or eligible for benefits, whether it's health insurance, retirement, et cetera. What we had was what was on the table, which were the retirement benefits of a couple of IRAs and another small, like $1,300 IRA. I mean, that's what was there. So could the court have done that? I suppose we could attempt to. Was the evidence there in this case? Absolutely not. It wasn't.
Right,
my time is up. Thank you.
Thank you. Rebuttal?
Okay, please, the court. I'd initially like to address the last statement by Mr. Oliver. The evidence in the record, if you look at page 48, which is the court's appendix dividing the property, indicates that Ms. Gust does have IPERS. She, at least in some fashion from her 2 part-time employments with the school, is getting some sort of IPERS benefits which were fully awarded to her. She was also awarded a portion of Mr. Gust's retirement accounts. Now, Mr. Gust got a larger portion of the retirement accounts because he took, by the court's calculation, almost $103,000 of the debt. Now, $20,000 of that may be anticipated interest, but he did not have cash available unless he cashed in his retirement account to pay off the $60,000 of credit card debt that the parties had accrued during their marriage. So the interest is a likely certainty. With respect to his retirement accounts, the Court of Appeals, in the language that the court read, says she has $167,000 in assets, including $135,000 in retirement accounts. That's what Mr. Gust has. Now, the court seems to indicate that he can use that to pay this alimony into the future. At $2,000 a month, if his retirement account is only used to pay his alimony obligation, it's gone in about 5 years. If he takes a corresponding portion, meaning I'll give her $2,000 and I'll keep $2,000, it's gone in 3 years. It's also, to me, it seems like it's double dipping to say you get this retirement account as part of the division of the property in this case, but now you need to use that retirement account when you retire to pay your alimony obligations so that for a period of years. I just don't think it makes sense that you can order to, especially when you don't get $1 million in assets like they did in the Schinkelberg case, to use $135,000 in retirement that's probably not enough to support you to pay your alimony obligation, and then it's somehow part of the property distribution.
Let me ask you a question. I mean, kind of reading the record and trying to figure out what was going on, because this district judge here does a really good job, and he's a really bright guy. It looked like your client may have done something a little unwise during the post-trial motions in filing a Chapter 7, which I guess was dismissed.
It was dismissed
because I assume they would really have to go under 13 and do a wage earner plan. But is that something that maybe complicated the post-trial proceedings when this issue of lifetime, whether the alimony was going to be lifetime or not, was really focused on?
It's possible it did. It's hard to know because the only ruling post-trial is on my client's motion to reconsider. There is no ruling in the record really on the motion to reopen the record with respect to the bankruptcy. I think it wasn't pursued after the bankruptcy was dismissed, but there's nothing in the record to indicate it. But as the counsel, as Mr. Oliver and Ms. Gust have said in their brief, it was dismissed for whatever reason, and I don't know that the reason is really clear in the record. And so the debts remain as they were at the time of trial. They were not addressed.
How expensive are modification proceedings? I mean, what would you quote somebody who came in and said, I want to pursue a modification?
In our firm, I would say, if you hired me to do Mr. Gust's modification, it's going to cost him $15,000 to $20,000, maybe more, depending on what gets resolved. I think that his trial counsel's fee is much higher than mine, and if you're going back to Mr. Pearson to do this, it might be even more than that. It's not uncommon for cases like this to exceed $20,000, $50,000, depending on what you're talking about. And I think, the evidence, there is no evidence about Social Security. There's absolutely no evidence about either party receiving an inheritance. So talking about these potential things that might happen, I just don't think that that's how you get there. I think you have to look at the evidence as it is now and predict what is a reasonable period for alimony. I don't think you can talk about Ms. Gust wanting to retire at some point and what her income will be if you don't correspondingly talk about what my client's income will be when he retires, and his income will go from $90,000 to $135,000 in a retirement account, and his Social Security benefits. I think you have to look at it both ways. I think the court has to look at the evidence that they had before it, and I think in this case, the lifetime alimony just isn't appropriate. I think you have to look at a point where it's reasonable for Mr. Gust to say, I'm not going to work this hard anymore to pay alimony when she gets to retire at some point, so then why can't I as well? And, assuring the court that the modification happens in the future, because either party, I think you just have to address it now and let the chips fall where they may, and then you address it later if there's some sort of extraordinary change.
So under your default proposal, would we have to tell the district courts that now they're going to have to start making detailed findings about what is in the contemplation of the court? In other words, in this case, wouldn't it, if we follow your line of argument, wouldn't we be telling district courts, you have to now start making findings about what's going to happen at Mr. Gust's retirement? I'm assuming he retires at X age. I'm assuming that all these other things this is the scenario at his retirement. Because without that, then aren't we left as appellate courts just really wondering what was in the contemplation of the court at the time the decree was entered when we're confronted with a modification?
I think that that's something that the courts already do. I think we cited the line of cases where the courts have repeatedly said that at 67, at 66, at 65, this is when this person should be eligible to retire. And we've cited those line of cases in our brief. And I think that's sort of where I think the courts routinely do that now. I don't think we're asking the court to do anything different. We're simply saying, and it's no different than saying, than Judge Hanson saying she can make 22.5 instead of 15 or instead of our 30. That's routinely what the courts do, is look at the evidence, make findings based on that evidence as to what the future of the parties will hold, and then rule accordingly.
Yeah, but on that point, he's really saying, I think she's able to make $22,000 now, not, she might be able to do that in 10 years, right?
That is the finding, but I think that it's the same type of finding as we're asking the court, by doing a lifetime alimony award, the court is essentially saying she's never going to be able to be self-supporting, so she's always going to depend on him for this large alimony award. And we're saying, but wait, I'm entitled to retire too. She's not entitled to live on the $2,000 a month in alimony if I have to work full-time until I'm 80 or 85 to pay that alimony award. And I think that's the assumption that the court had to make in this case, is she's never going to be able to get there.
Thank you, Counsel. The case is submitted, and we'll now hear the arguments in State v. Young.